Looks like attorneys are ready. We're here now on the matter of State versus Cole, and we'll begin with Ms. Wilson.
May it please the court. This case presents the question of whether, consistent with the state and federal constitutions, a defendant may be convicted for prohibited person in possession of a firearm based upon a civil domestic abuse protective order that was entered via a consent agreement. After the filing of Mr. Cole's brief in this case and prior to the filing of the state's brief, the United States Supreme Court decided United States v. Rahimi. Given the similarities of the claims between the two cases, I'm going to tailor my Second Amendment argument today to the application of Rahimi to this case. Rahimi was convicted of possession of a firearm while subject to a civil domestic abuse restraining order entered by consent agreement. So factually, it would appear to be very similar to Mr. Cole's case. Rahimi held that a person may be temporarily banned from possessing firearms when a restraining order contains a finding that an individual poses a credible threat to the physical safety of an intimate partner. This black and white holding would appear to control the outcome of this case, but it does not. Rahimi posed a facial challenge to 18 U.S.C. 922 G8C1, which bars an individual from possessing firearms based on a finding that he posed a credible threat to the physical safety of another. Rahimi found the historical analogs of surety laws and going armed with intent laws to be similar in nature, in that they disarmed, or at least temporarily disarmed, people who posed a threat to other persons. There are two aspects, however, that Rahimi did not address. First, whether 18 U.S.C. 922 G8C2, the subsection applicable to Cole, would suffer the same fate. Again, subsection 1 requires a judicial finding that the defendant posed a credible threat. Subsection 2 does not, by its terms, require any such judicial finding. It simply prohibits the use, attempted use, or threatened use of physical force.
So on that point, under Iowa Code 236.32, it says that if the factual basis for the alleged domestic abuse, so first a petition has to allege domestic abuse, and if that's contested, the court shall issue a protective order based on a finding of domestic abuse. But if Mr. Cole is going to concede the abuse, then why doesn't that in itself satisfy our finding that he agrees that he's dangerous?
I'm glad you've raised that, Your Honor, because I do want to clarify something in my briefs. Iowa Code section 236.5, I believe, is the provision under which this order in this case was entered. And under the current version of that statute, which was amended in July 2002, a consent agreement does not require a judicial finding of domestic abuse. But
Forms, is it the order that the defendant is acknowledging abuse? Isn't he just consenting to an order being entered to stay away?
That is the form in Mr. Cole's case. I do want to clarify, though, that the version of 236.5, in effect, at the time of Mr. Cole's protective order, did actually require a judicial finding of domestic abuse for even a consent agreement. So I'm going to acknowledge at the outset that this may pose a weakness to a facial challenge under the old statute, not necessarily under the newer version. But I also want to point something out that is relevant to his as applied challenge, and that is the nature of the protective order in this case. So while the statute may have required a finding of domestic abuse, you will not see it in Cole's order. The civil protection order does list a number of findings that are required by statute. That the court has jurisdiction over the parties and the subject matter, that the defendant was provided with notice and an opportunity to be heard. Among those findings, there is no finding that he committed an act of domestic abuse. But it's not just that the form is silent on it. It is the fact that there is a provision in this form that can be checked if the court finds domestic abuse.
Have, Ms. Wilson, what about, I mean, I have trouble getting around that Mr. Cole consented to this order, including that he not possess firearms for a period of a year. And I guess, does the Second Amendment or Article 1, Section 1, do they prohibit somebody from just consenting in a legally binding way to not possessing firearms for a year? And I have trouble with the proposition that those provisions forbid that if you voluntarily consent, because presumably if that order hadn't been entered, maybe the victim could have gone some other route, like press criminal charges.
I think that brings up the question of how do you waive your Second Amendment rights?
Form that says you are agreeing not to possess a firearm for a year. That sounds like a pretty good waiver, right?
He consented to entry of the order. I do not see his signature on the form, but...
Correct, but he did consent to it. He was there, yeah.
Unfortunately, this form is all the record we have of that hearing. We don't know what was said. He apparently did not appear with counsel.
Wilson, that this is an incredibly common order that's entered, and oftentimes without a record, perhaps not even a court reporter, let alone maybe, but by consenting, isn't it true that they usually do it because they don't want that finding of domestic abuse? So I'm actually kind of surprised checkbox 3 is even on page 2, because if it's going to be consent, in my experience, it was because they don't want that finding.
I will not dispute that, Your Honor. It does make perfect sense.
True, then the statutory change is interesting, right? I mean, if at this time judges were entering these orders, consent orders, without a finding of domestic abuse, despite what the statute said at the time, coming back to your question of what to think about the statutory change, does that suggest maybe that the change was to reflect what the actual practice was? Because this form is out here allowing district courts to enter these without a finding.
Been, Your Honor. And the other thing I would mention when it comes to issues of waiver, for example, again, we don't have the record of what transpired, but the state cites several briefs or several cases that talk about the duty of a defendant to move for an enlargement of findings in order to preserve an issue for appeal, for example. Obviously, we're not on appeal from the entry of the protective order. But I am actually fond of Justice Vogel's dissent in Sims versus Rush, where she points out that it's the plaintiff's burden to get the protective order, and the court is to find sufficient evidence to issue that protective order. Why would a defendant be burdened with the challenge to it? So, and this kind of ties in to the issue of collateral attacks, because that is another point. Yes.
Law, kind of the interrelationship between federal and state law here. I mean, the C2 order was not an issue in Rahimi, right? So at least on its face, under 724.26, Mr. Cole is subject to a protective order under 922G8, correct? So if you think that's wrong, as a technical matter, what would be the holding in terms of what is constitutional and what is not unconstitutional? Are we adjudging the constitutionality of 922 G8C2? Are we looking at the word subject to and concluding he's not subject to because he couldn't be subject to? How would we kind of parse through that?
These statutes are written, they're intertwined, as you mentioned. So unfortunately, you do have to consider both 724.26 and also 922 G8 in order to resolve this issue. So with the supremacy clause exists. So if the US Supreme Court were to come down and say, yep, C2 is constitutional, this court would have to follow that ruling. As you noted in Rahimi, they didn't speak to C2. So it is open for interpretation. This court could say 922 G8C2 is unconstitutional as applied to this particular defendant in this situation, and that therefore 724.26 also cannot be applied to him. But I do briefly, yes.
Be interesting, because if we said that, I mean, he could be prosecuted under 922 G8C2. Our holding would have no preclusive effect on a federal criminal court proceeding.
Jurisdictions, that is what would happen. You can only control what happens within the boundaries of Iowa, and that seems like a good point to go into the Iowa Constitutional Amendment, Article 1, Section 1A.
But I have one more question. So doesn't that get to kind of the collateral attack issue and kind of what are we doing here in this criminal proceeding when we have what is undoubtedly a procedurally proper protective order?
There are numerous cases cited in the briefs, that federal circuit cases that talk about collateral attacks. And I think those need to be revisited in light of Rahimi and the Second Amendment case law. One of the cases cited by the state is Baina out of the Eighth Circuit, and it refers to collateral attacks on uncounseled convictions used for sentencing enhancements, and said that was okay. I mean, it is a collateral attack, but even that case law has changed. Yes, you can collaterally attack uncounseled prior convictions if it violates the right to counsel. So now we have what we know to be an individual right to bear arms, and those cases on collateral attack need to be re-examined because, generally speaking, we do not permit criminal prosecutions based on constitutionally protected conduct.
I think you said that Rahimi was a consent order. Does that influence our approach to this? In the sense that the Supreme Court didn't seem disturbed about reaching the merits of the Second Amendment. Does that play anything?
Actually, I would like to be able to stand up here and say that Rahimi addressed both the waiver and the collateral attack questions. It did not, and I looked in the briefs for Rahimi. They were never addressed in the briefs. So Rahimi tells us nothing, which is why I think this court is open to re-examining those federal circuit cases.
But I mean, in a way, it kind of did, right? It seems to indicate that you do allow these collateral attacks, but in that case, they just found on the merits there was no issue.
Rahimi went to the merits, and it's always interesting to try to read into something the court didn't address. So I don't want to say, yes, it's what it means, but it's an interpretation of what it means. And just briefly on the state constitutional law question, I think it's helpful to lay out the timelines of what happened exactly. We have the constitutional amendment taking effect November 8th, 2022. His protective order was July of 2022, so easily predating it. His first offense was, actually, his protective order was March. His first offense was July 2022, predating the amendment. But his second offense was November 10th, 2022, or at least it was reported after the amendment. So there is a question of prospective and retrospective application.
Ms. Brooks?
May it please the court? Opposing counsel. Both the state and federal constitution recognize a fundamental right to keep and bear arms. Neither constitution, however, demand an absolute right. Iowa Code Section 724.26 makes it a crime to possess a firearm while subject to a domestic abuse protective order that meets certain criteria under 18 U.S.C. 922G8. Mr. Cole challenges Section 724.2A both on its face and as applied to him, as he did below, and the order below indicates that it considered and ruled on these. However, Mr. Cole consented to an underlying domestic abuse protective order and its firearm prohibition.
Consented to the entry of an order telling him to stay away, but he never consented to a finding of domestic abuse?
The finding of domestic abuse, I think, is an interesting question that this case raises, in that my reading of chapter 236.5, which I believe my opposing counsel correctly stated, that in 2022, the way the law read of 236.5 is that before a court could enter either a consented or a non-consented protective order, that a finding of domestic abuse was necessary.
This order does not include it, does it?
Next to the line that says if domestic abuse assault happened is not checked. But I do think that when we look at some of the cases.
For a motion of the court to rule on that issue in particular. My point is it's collateral from both perspectives, correct?
0.5 proceeding, the state, I don't believe, was involved. But at the lower court, in the district court case, the state did argue that the protective order that was in place is meaningful and shows that the district court made certain findings. And I think when we look at the district court, or the protective order.
Take judicial notice of actual practice of how 236 orders were issued before the statutory change. And I only ask because, having issued many of them, I think the commonly accepted practice is reflected in the current statute, despite what the, the prior statute said.
Certainly in researching this case and briefing it, questioned it myself if it was even necessary, because I was looking at some of the cases in the Chapter 235 proceedings that were then appealed and what findings were necessary or not necessary in those cases. And ultimately, my determination, my conclusion was that the wording of it in 2022 required it. Now, in practice, I think that can perhaps be a factor, but I think that when we look at some of the cases that say, if it's not stated in the order, but it's necessary for it to happen and it's not challenged on appeal, we can assume that that record includes that finding. But I want to be clear, I'm not hanging my hat on a finding of domestic abuse assault in this order or out of this order. That certainly, I think this court could very fairly find that a finding was made there, but that isn't the end-all be-all of why I think this protective order is both constitutional under the Iowa Constitution and the federal Constitution. And I think looking at the language of this protective order, understanding that we're using 922G8 as a definition in our elements of the 724.26 statute. So this court's holding is not necessarily determining the constitutionality of 922G8, but it's using, the Iowa Code uses 922G8 as a definition and imports that into our 724.26 criminal statute. That being said, the protective order at play here, it restrained Mr. Cole from harassing, stalking, and threatening the protected party. It prohibited the use of force, threatened force, and attempted force against her. The order prohibited further acts or threats of abuse. Under Chapter 236.5, a protected party can extend the order if the court finds that they continue to pose a threat. All of these things show that when a court enters an order under Chapter 236.5, it does so meaningfully. And we have to look at those orders, not that it was an afterthought, not that it just checked a box, not that it is form language, that these orders are put into place because they mean something.
Hanging your hat on G8C2 because of the or conjunction?
So from a, backing up perspective, the 922G8 has three parts. The first part being A, the notice and opportunity to be heard. There's no argument here that he didn't have a notice and opportunity to be heard in this case. Then B is that preventing from harassing, stalking language. There's also a subpart in that B, which is also a conjunctive or. Then finally we get to C. So 922GC sub I is that if someone poses a credible threat to the physical safety of their intimate partner. CII is the language of prohibited from committing acts of force, threats of force, or attempted force.
Concerned about your comment a minute ago where you said that we should be able, even after the fact, the state should be able to look back at that protective order and say, well, even though they didn't check that box, it can be assumed. I don't know of a case where anybody in their right mind would have entered a consent order with a finding of saying, and it's automatically assumed finding of abuse. Why would they not just roll the dice?
I agree that that puts this case in a peculiar situation from a factual perspective.
Talking about a legal assumption, you think it's reasonable to assume. I just beg to differ with that argument.
I can certainly understand that perspective. And the case that I cited in my brief is, I believe it's U.S. Cellular v. Des Moines Board of something. And that case talks about when the finding is necessary for the order, that if it's not challenged, that we can assume that finding. And I can certainly understand if this court doesn't want to take the leap to make as a determination that assault actually, in fact, was found in this order. But I think that there are grounds for this court to do so if it found reasonable. And I think that looking at the other language of that order is where we get to this credible threat, this belief, this understanding that this individual needed to be restrained from their intimate partner. I think that when we look at the order and understanding that district courts don't just order this because two people came to court and said, I think we need a protective order. The district court looked at... Well, I guess I think from my perspective, we can presume regularity. We can presume that when a court enters this order, it does so meaningfully.
Meaningfully, but I struggle to say that there couldn't be a lot of reasons that the court might want to say, you two obviously have problems. Something's going on here. You don't want to have a hearing. You don't want to have a finding of abuse. Maybe neither of them want to have a finding of abuse against them. And so they're willing to go their separate ways. And that's good for everybody involved, potentially. And it just, with the checkbox and the judge's refusal to check it, it's just very hard for me to get over the hump.
I want to point out, too, that while Chapter 236.5 has the language about a consent order and needing the finding of domestic assault before entering that order, 922G3 has no requirement that there be an act of domestic assault committed. 922G8 only requires those three A, B, and C requirements. So a finding that domestic abuse assault happened under 923G8 is not necessary for these orders to go forward. Finding that a domestic abuse assault happened, I think, furthers the state's position that this order shows that this person poses a credible threat, poses a meaningful danger.
It seems pretty important. As I read that case, the court is sort of repeatedly saying that there was an express finding in that case, and that's, as your opposing counsel emphasized, that really separates the cases.
Rahimi, the protective order in Rahimi had both the CI and the CII finding. And so this U.S. Supreme Court was very clear in saying we are intentionally only deciding the CI because it's not necessary to decide CII today. But it also cautioned, with that being said, nothing in this, it said nothing in this decision should say that someone, a category of people that pose a danger of firearm misuse couldn't still be constitutional. So while it didn't decide the CII issue, I think that the reasoning in Rahimi, as the Sixth Circuit has said, comports both with the CI and the CII. And so when we're looking at Rahimi and we're looking at the why and the how of a regulation, the why of 922 GC sub II does not change between the I and the II. The why is the same. We're looking at the how. Is this how similar enough to our traditions that if someone is under a protective order that has these findings, is that similar enough, is it relevantly similar to the principles that underpin our regulatory tradition? And if the CII, like the CI, has that judicial finding and has the notice, the opportunity to be heard, there's an opportunity here for Mr. Cole to not consent to the order. The court, to your point, Justice May, that the court could have entered this order without certain language, but it chose to include certain language. And I think that I believe it's the Third Circuit in Boyd in 2021, talked about this, that under CI versus the CII, that we don't need to assume that just because a court didn't say credible threat, that this person didn't pose a credible, that the district court didn't have credible concerns about the danger that this individual poses to their protected party, or to their intimate partner.
The retroactivity issue with Amendment 1A, especially if one of the second criminal charge at issue was reported on November 10. And is the effective date of 1A November 8 or of some days later when the election results are certified?
From this court's decision in NS is that the effective date was December 1st of 2022. But that aside, I do think that looking at the conduct in this case, what these are criminal actions for our relevant retroactivity period, is we're looking at crimes that were committed in July and crimes that were committed in August of 2022, of a protective order that was entered in March of that same year. So all of our relevant conduct has happened before November or December, whichever period it is that we're looking at. But I do think, sorry, is there a question? Yes. I do think that the retroactivity bit brings in an important or an interesting thought in our relation between the Second Amendment and what that right protects and our Article 1, Section 1A and what that right protects. And I think that Justice Barrett in her concurrence in Rahimi really gets to this point of we're looking at the scope of the right, and the scope of the right in looking at the way we address either constitution tells us that the right exists. The scope of the right is where the ability of the state to intervene is. So with the strict scrutiny, the scope of the right is different than under our Bruin and Rahimi analysis, where the scope of that right is different. So this isn't saying that the state adopted the Second Amendment and now we're using two different tests to attack the same constitutional right. I think that under Article 1, Section 1A, we have a distinct right than we do under the Second Amendment of the federal Constitution.
The waiver issue and the issue of whether your collateral attack cases maybe are no longer good law, at least implicitly, because of Rahimi.
And of my review of some of the circuit courts, there's a bit of I won't go as far as to say as a split, but there's not agreement on the cases that address the historical tradition pre-Bruin, if we should just throw all of them out. Because remembering that Bruin did have an element, they recognized that the courts were correctly addressing the first part, which is looking at the history and tradition. We just threw out the means end scrutiny analysis. So I think to your point, Justice McDonald, is that when we're looking at the collateral attack issue, this isn't a question of if it's relevantly similar or if there's a historical tradition or if there's a means ends need to it. So the idea that we can look at for something, and I think the concern with the collateral attack here is not that someone can't challenge as a matter of law that 922 G8 CII isn't constitutional, but it's when we start digging in and start asking questions of, well, should this order have even been entered in the first place? What were the facts of that order? Would that order, is that order valid? Should it be void? Those are questions where we start getting into collateral attacks. So
the collateral, I'm interested in your answer, but it seems to me on the collateral attack question that it doesn't really come up if you have a facial challenge, because there you're saying on its face the statute's unconstitutional because it makes anybody subject to this order, they can't have a firearm. But once you're doing an as-applied challenge under facts, then it seems to me you do run into this collateral attack problem that you're outlining right now. Am I correct?
With that. I think that when we're looking at the specific facts of one individual, and we start asking questions of what was the application for in the Chapter 236 proceeding, and what was alleged, and what did the court find, and was it necessary to actually separate these people, those are questions that are begging the validity, begging the predetermined facts, the underlying facts of the protective order, and that's where it gets dangerous.
Or waiver issue too, because again, with the court in Rahimi mentions the consent but doesn't do anything with it. Whereas for a facial challenge, it doesn't matter, but it seems to me for a as-applied challenge, the consent might be relevant.
Consent bit was, for the most part, unaddressed in Rahimi beyond the fact section. But I do think that looking at the facts of this case, and I see that I'm over time, if I could. Yes. That in the facts of this case, looking at the nature of it being a consent protective order, I don't think we should incentivize individuals to insulate the record in a way that we say, you can't ever review the facts of my case because the protective order, the application's sealed, the court made no fact findings, and therefore, even though the court found that I'm prohibited from further acts or threats of abuse, that I can't be subject to 922 G3, G8's firearm prohibition.
So are you saying that you couldn't have gotten into the 236, or the state, maybe, the state below couldn't have gotten into the 236 file? And, let's say there was an affidavit filed by the victim here, and that couldn't have been added to our file here?
From my understanding, the Chapter 236 proceeding is separate, is outside of our record, but to the point of if the state could have brought it in there. And I thought about that too. I think that the application itself would be of limited relevancy because those are still just allegations. So like unlike a motion to dismiss where we're looking at the minutes of testimony and taking them as true, I don't think our same review would be there for looking at a application under 236.
That's important because you just said, just the mere entry of the order, there could be an assumption that there was domestic abuse there. I have seen many an application that are really, really slim, and I probably would have denied, but for the lawyers in the case or lawyer are recommending, let's just do a consent because they don't want the parties to get into any more trouble. But it would have never, in my book, qualified as domestic abuse, but the parties are willing to say, we're going to stay away from each other. And as Justice May said, in the interest of safety and for everyone else, I thought that was a good idea, and I entered an order. So I do think it's important to be able to dig into that, and I also think you should be able to access it.
Yes, to the extent that the state could have accessed it at the district court, I'm not contesting that one way or another. All I'm saying is that if we did, all that we would have are allegations in the application. It still wouldn't resolve the factual findings that the district court made on the veracity of those allegations one way or another. And so unlike a motion to dismiss, where we're looking at the minutes and accepting them as true, I don't think the same could be said about an application in a 236 proceeding and accepting those allegations as true for purposes of a constitutional question. And so I think that's where the distinction comes from, if the application could have been part of the record or if it needs to be part of the record and what part of that could influence this court's decision. If there are no further questions, the state asks that this court affirm. Thank you.
Wilson.
May it please the court. If NS says the effective date of Article 1, Section 1A is December 1st, I have no issues with that. I will defer to the court's ruling. So that still brings up the question of prospective, retrospective application of the amendment. And I addressed it a little bit in my brief. Obviously, we did not have an explicit right to bear arms provision in our state constitution prior to the amendment. However, there's some discussion that in Heller that this would have been considered a pre-existing right under English common law. The convention members would have been familiar with it. I also did a notice of additional authorities for Article 1, Section 1, because I realized language in that article talks about defending life and protecting property. Well, at the time of the convention, how were you likely to do that? Probably with the use of firearms. So if this court were to find that we did actually have an implicit understanding that people had a right to bear arms, then this is not a substantive amendment and you would be able to apply it retroactively. However, I also recognize the general rule that constitutional amendments are generally considered to be prospective unless they specifically say otherwise. But you can look at cases like the Merritt case cited by the state and the Harrison case, where there is some discussion on prospective and retrospective application. Specifically, Merritt talked about how they adopted strict scrutiny after McDonald made the right to bear arms personal to individuals in the states. So Iowa did not have the opportunity to address that, but that's an interesting question. But I did briefly want to get into that. I do not believe the statutes meet strict scrutiny, again, because of the lack of judicial findings that he committed domestic abuse or posed a threat. I'm open if anybody has any questions.
Difference that Mr. Cole was not represented by counsel at the time he entered into this consent order?
I think it's a question of what did he truly understand of what he was entering into. And of course, we don't have the record to know what the court told him. Did he understand the firearms prohibition? Beyond that, I don't know that it means much more than that.
Enter into these consent orders to avoid a finding of domestic abuse so that they can continue to have their firearms to hunt, or maybe they need them for their job. Maybe they're in law enforcement. And do we want to interfere with, do we want to, I mean, we're talking about incentives, why people enter into these things. And the legislature decided consent orders without a finding is a good thing. So should that influence how we decide this case?
The other side of something being tailored for a government interest, in that, if that is the practice in the state to promote the entry of protective orders to protect people who may have been subject to domestic abuse, then absolutely it is furthering a state interest by allowing this entry of these consent decrees without a specific finding that might otherwise make it more litigious to enter the protective order. For these reasons, we would ask this court to reverse.
State versus Cole is hereby submitted, and we will recess for the morning.